the purpose of their exam, specifically to what they were asked, and that was MMI and impairment. So the only doctors that you have after that point are the medical records and evidence and Dr. Fuentes, who is specifically addressing extent of injury. We believe that his report holds greatest weight of the medical evidence beyond the state doctor who wasn't asked to address extent, beyond the RME who was not asked to address extent. He had to limit his report to just the impairment rating in MMI date. We hope that you do find that Dr. Fuentes' report explains exactly how these injuries were and should be part of the claim. In the event that you find all these conditions to be part of the claim, we do not have an impairment rating at this point that addresses all those conditions. I believe even Dr. Dionne's report does take into consideration the head of the concussion. And with that, she does find that he's not at MMI. Dr. Bales does take into consideration the cervical strain, which the judge found was not part of the injury. But he does take that into consideration, and that's how he, I guess, came up with the 6% impairment rating. We believe that the preponderance of the evidence does support that the claimant, based on the injuries that are in dispute, there is not a valid.
Let's go through each of these different injuries. Concussion, right?
Yes.
What else? Tinnitus.
Left shoulder sprain.
Okay.
Then tinnitus. Then the disequilibrium, hearing loss, and then cervical strain with a T as in Tom. 2, 3, 4, 5, 6 conditions.
Okay, so let's kind of go through each of them. So the concussion, I get left shoulder strain. I get tinnitus. When did he first complain about tinnitus?
Let me get that, Judge. Hang on, sorry. Tinnitus, let's see. So the Dr. Fuentes is medical. He's relating I believe, the tinnitus to the concussion and to the disequilibrium, all kind of in the same, and that's on in his 5-page letter, Judge.
Okay, but when does it first referenced in the treatment notes? Like, is he ever? I mean, if he's having tinnitus, as I understand tinnitus, it's not something that would just pop up. It would be something that he would have, since the accident, and so. Is it not brought up until Fuentes, or?
Fuentes started treating him shortly after the accident. So it is, let me.
When does Fuentes first mention he has tinnitus, I guess? When does any medical provider first mention he has tinnitus? And if you know Mr. Poteet, you can let us know. This isn't a test. I just had to go through this quickly.
And I'm looking, Judge, sorry.
Me too.
In the same from disequilibrium and hearing loss, when are those first mentioned?
So I'm looking at the examination findings. This is in our exhibit page 88. These are in the records of Advantage Healthcare. In June 4th, 2019, I see where the doctor has diagnosed him with the tinnitus, disequilibrium, hearing loss. And he specifically says concussion without loss of consciousness.
And when in the accident, give me the date again on the accident.
June 4th, 2019.
The date of the accident, what is that?
Oh, I'm sorry, 10/24/18.
And so the first time he's ever, so 10/24/18 is the accident. The first time tinnitus, disequilibrium, and hearing loss are mentioned in any of the medical records is June 4th, 2020?
No, 2019.
19, so about 6 months after the accident?
Correct. And that's just from Advantage. He did a treat with Nova immediately after. And I'm just skimming through just to make sure, checking their diagnosis to make sure that they didn't mention that earlier.
And Mr. Poteet, if you want to check that too.
Yeah, I trust what she's saying as far as the date is concerned. If you look at the records from that Dr. Dory summarized, you will see the objective test, the CT scans, etc.
What page am I looking on? And your exhibits or her exhibits?
It's my exhibit, and it's on page 54. And you will see there's a CT scan that shows some of the conditions that were related, and then it says no thoracic or lumbar spine fracture, which, I mean, she's not pursuing a fracture. And then it says no, the head and cervical spine without contrast shows no acute intracranial hemorrhage, no midline shift, moderate degenerative change on the cervical spine.
Okay.
So this is from October 24th, 2018. So that's the objective diagnostic testing.
I get that. What I'm trying to get to is the tinnitus, disequilibrium, and hearing loss. When is that first referenced?
I think it's June 4th, 2019, when he went in to see Dr. Fuentes.
And I would agree with that.
Okay. Anything else you wanted to say?
No, Judge, I think you've got the records in front of you. And again, we think that our causation analysis by Dr. Fuentes provides the sufficient explanation by our expert that indicates that these injuries are included.
All right. Mr. Poteet, did you want to say anything?
Just very briefly, Your Honor. Just so we understand, the burden of proof on establishing any of these conditions as being compensable is on Mr. Casanova.
And that's based on a preponderance of the evidence, right? There's no deference to the commission.
There's no, for your sake, there is no deference to the commission. All you get is you get to look at it, you get to understand it, and then you make your own determination. But what you do need to know, with the exception of the cervical sprain and the left shoulder sprain, all of these conditions do require expert causation evidence within a reasonable medical probability. And
isn't that done by Dr. Fuentes? And also there was a neuropsychologist as well. I don't remember his name.
Yes.
There is evidence. Whether you find it competent or not is a different matter. And
right.
We do not believe that the totality of the medical records support the expansion of the compensable injury to the disputed conditions. At a minimum, in my opinion, the cervical sprain, maybe, but the rest of it, I think the ALJ, the judge that did review it, has provided you with a very clear outline why she does not believe that they are related. And this is, generally speaking, how these cases go. We believe that the opinion of Dr. Dory's explains in great detail why these conditions should not be included, including referencing the medical records from initially after the accident. As you have pointed out, Judge, the diagnosis of these other conditions did not occur until nearly 6 months later, or over 6 months later. And it's not clear to me in his attempt at causation that he links this appropriately. And so, Your Honor, we believe.
Are there any other, I guess I didn't see this, are there any other accidents that are between October 24th, 2018 and June 4th of 2019? Did he have any other falls or any other accidents that we know of?
Not that we know of.
Okay, go ahead. I'm sorry, I didn't mean to interrupt you, Mr. Poteet. Go ahead.
Well, I kind of lost my train of thought, but I think you've gotten the gist of both sides' argument, and I don't need to beat a dead horse here. So Well, I think what I was saying was I think you know, with the cervical sprain, because the designated doctor did find that to be included in his analysis. And there's nothing preventing the designated doctor from saying, you know, there are these other conditions out here and we need to consider them. There's nothing that prevents him from doing that. Just as Ms. Wyatt noted that Dr. Dorries was not appointed to address the extent of injury, there's nothing that prevents them from making a comment and telling you they believe that there's something else going on. And this designated doctor chose not to do that. He did specifically indicate that the cervical sprain was related, but did not say anything else about any of the other conditions.
Okay, this has been interesting. Thank you for bringing this to me. And again, we don't handle these a whole lot, although I've handled a few. So I'm gonna, as I understand this, and correct me if I'm wrong, this is what I'm inclined to do, and then we can kind of talk about what happens if I do this, is I think that I believe I'm going to rule that the concussion, the left shoulder sprain, and the cervical sprain are compensable injuries, but not the tinnitus, disequilibrium, and hearing loss. If that's the case, as I understand it, I would have to send it back to the commission to make a determination of MMI and an impairment rating. Is that right? Am I,
That is
if
correct.
that's my ruling, that's what would have to happen, right?
That is correct.
Okay. All right, then that's my ruling. Can you give me a judgment that says that?
Yes, and just for your information, Judge, and you may be aware of this, but any judgment, it has to be on file with the division for 30 days.
30 days, right. You got, the way I've done this before is I think you send me the judgment.
Yeah,
I'm sorry.
We simultaneously send that to you, the proposed judgment, and the Division of Workers' Comp.
And I can't sign it for 30 days. Is that the way it works?
That's correct. And
Okay.
if the division takes no action within 30 days, then you sign it. And generally speaking, they take no action. I mean, it's really.
What can they do at that point? Can they do something in the 30 days? I've never had them do that.
The chances of that happening in this case are extremely minute. Very unlikely to happen. If they chose to do something, what they would do is intervene and say, Judge, you can't do that.
Okay.
So, but the chances of that happening are like 0.0001.
So theoretically, they could intervene and say, Judge, that we want to take a position on this case before I enter my judgment. Is that why the 30 days are there? Okay.
But that's not going to happen in this case. I would be very, very surprised if that happened.
Okay, well, good. So you guys are going to jointly prepare a judgment for me?
Yes.
Can you also include on that, make sure you email it to me directly as opposed to my coordinator, and say that this trial was held on, at the beginning, say the trial was held on March 24th of 2022. And anything else that we need to go over today?
I do not believe so.
I don't think so.
All right. Well, thank you for handling this so efficiently. And if there's anything else you need from me, let me know. And will you include whatever date I'm supposed to sign this by?
Yes.
On the email.
Yes.
Okay.
Or maybe put something on top of it, like in black letters, do not sign, like on the actual judgment, so it doesn't get. We go through hundreds and hundreds of orders every week, and so it's useful to know, don't sign this. But Casanova is kind of a unique name, so I'll probably remember it. So, all right, guys, you guys have a great day, and thank you, and we'll see you soon, okay?
Thank you, Judge.
Thank you, guys.